Greetings, everyone. My name is Ahmed Negron Perez, and I would like to welcome you all to the webinar, Information Sharing and the Family Educational Rights and Privacy Act, FERPA, and the Health Insurance Portability and Accountability Act, HIPAA, for schools and post-secondary institutions. This webinar is hosted by the U.S. Department of Education's Office of Safe and Healthy Students in collaboration with the Readiness and Emergency Management for Schools, or REMS, Technical Assistance Center. Now, I would like to turn it over to my colleagues from the REMS TA Center.
Thank you, Ahmed. Before we begin, I would like to go over a few housekeeping items. Our call today is set so that only our presenters can speak to the group. However, we will be taking questions. You may submit your questions at any time during the webinar using the online Q&A chat function located on the lower right side of your screen. Our presenter will respond to questions during the Q&A session at the end of the training in the order in which they are received and as time permits. Just above the Q&A chat window on your screen, you will see a file share pod that contains a downloadable PDF of today's webinar slides. Please click on the file name and then click the Download Files button to save the webinar slides to your computer if you so wish. Let's get started. Today our presenter is Ellen Campbell, Deputy Director of the Family Policy Compliance Office at the U.S. Department of Education. FPCO is responsible for administering the Family Educational Rights and Privacy Act, or FERPA. Ellen has worked in the area of student and family privacy issues since 1986 and has been instrumental in bringing to the educational community a better understanding and appreciation of the rights that parents and students are afforded by FERPA. She routinely assists senior officials at the department on matters involving the applicability of FERPA to major policy issues facing the education community. She also interacts closely with other federal agencies to ensure that their programs do not conflict with parents' and students' privacy rights. In 2007, she authored a chapter on FERPA in the Encyclopedia of Privacy, which was published by Greenwood Press. Ellen?
Thank you. I'm delighted to have the opportunity to talk to you today about the Family Educational Rights and Privacy Act, or FERPA. It's very important that school officials understand the basis of this federal statute and respect its requirements concerning maintaining the privacy of information contained in students' education records. Towards the end, I will also provide you with some information about the HIPAA privacy rule, but mostly we will focus on FERPA. Understanding certain provisions of the law can help you maintain safe schools and campuses. The information in this presentation will apply to elementary and secondary schools as well as to colleges and universities. Where there is a difference, I will point that out. Congress passed FERPA in 1974, around the same time that other privacy statutes were passed. Congress has amended FERPA approximately 11 times since its original enactment. Typically, when Congress amends the statute, the Department issues new regulations reflecting those changes, as well as changes based on administrative experience. What we're going to talk about today are the FERPA regulations by which the Department, through my office, the Family Policy Compliance Office, or FPCO, administers this important law. FERPA applies to educational agencies and institutions that receive funds under any program administered by the Department of Education, or ED as we sometimes call it. Most private and parochial schools at the elementary and secondary levels do not receive such funds and therefore are not subject to FERPA. Most colleges and universities, both private and public, do receive ED funds and therefore are subject to FERPA. By educational agency or institution, we typically mean a school, school district, or post-secondary institution. FERPA is a federal law that affords parents the right to have access to their children's education records, the right to seek to have the records amended, and the right to consent to the disclosure of personally identifiable information from education records, except as provided by law. Parents may also file a complaint with FPCO alleging violations of their rights under FERPA. When a student turns 18 or enters a post-secondary institution at any age, the rights under FERPA transfer from the parents to the student, and he or she is known as an eligible student. However, even though the FERPA rights have transferred from the parent to the student, nothing prevents the school, such as a high school or a college or university, from disclosing education records to parents under one of the exceptions to consent that might apply. The exception that is most utilized in this case is the disclosure to parents of a dependent student. That is, if the parent or parents claim the student on their IRS tax form, the school may disclose any and all information from the student's education records to the parents. Understanding the definitions in FERPA will help you understand how to apply this law to your particular situations. The most basic definition is the term education records. Education records are defined to mean those records that are directly related to a student and maintained by an educational agency or institution or by a party acting for the agency or institution. Health records on students maintained by elementary or secondary school are education records subject to FERPA. As we will explain later on in the presentation, the HIPAA privacy rule does not apply to records that are protected by FERPA. We will also later talk about health records at the post-secondary level when we discuss the FERPA-HIPAA connection. Another important definition to keep in mind is the definition of personally identifiable information, or PII. This works together with education records in determining what information must be protected from disclosure. In 2008, we amended the definition to include some more items. PII include not only direct identifiers, obvious items such as name, address, social security numbers, but also indirect identifiers that, as we see on the next page, would have the effect of identifying a student. So the standard under FERPA is, can a reasonable person in the school community, someone without personal knowledge of the circumstances, identify the student? If they can, then it is personally identifiable to that student. Schools are required to annually notify parents and eligible students of their rights under FERPA. There is a model notification on FPCO's website that schools can download and adapt to their situation. Colleges and universities are required only to notify eligible students. Now, as we'll talk about in a bit, the annual notification must include the criteria for who your school considers to be a school official and what your school considers to be a legitimate educational interest. We have sample language for that in the model notice as well. This will become evident why this is important as we go through the presentation. Some schools include their directory information notification as part of their annual notification of FERPA rights. You're not required to notify parents and eligible students individually, but you need to do your public notification in a manner that would reasonably inform them. The general rule in FERPA is that a parent or an eligible student must provide consent before PII from the student's education records are disclosed. The consent must be in writing and be signed and dated. It must specify the records that may be disclosed, state the purpose of the disclosure, and identify the party or class of parties to whom the disclosure may be made. However, there are some exceptions to the FERPA general consent rule. A few of these exceptions relate to the matter of keeping schools safe. One of the most used exceptions to FERPA's general consent rule is the disclosure of PII from education records to school officials within your school that have a legitimate educational interest. Of course, this type of disclosure happens every day in the life of a school. But it's important that you understand this provision and your school's responsibility to make sure it's followed properly. Although school official is not defined in the statute or the regulations, we have interpreted this term broadly to include officials within your school, such as a teacher, school principal, president, chancellor, board member, trustee, registrar, counselor, dean, admissions officer, attorney, accountant, law enforcement unit official, human resources professional, information system specialist, and support or clerical personnel. These are just some examples. A school official is generally thought to have a legitimate educational interest if the official needs to review an education record in order to do their job, to fulfill his or her professional responsibilities. In 2008, we issued regulations that, among other things, clarify that the school official exception includes contractors, consultants, volunteers, and other outside parties to whom a school has outsourced institutional services or functions that it otherwise would have used employees to perform. For example, a school might outsource its legal services to a law firm in town, or hire an IT company to help them set up its electronic file system, or contract with a security company to provide security services. As we will discuss, it is this clarification of the school official exception that permits schools to utilize outside experts on threat assessment teams, utilize outside law enforcement services, and outsource other institutional services or functions necessary to assist the school. Schools should always use good judgment in determining the extent to which outside parties acting as school officials need to have access to PII from students' education records. Therefore, it's important that you follow the outsourcing requirements in FERPA. The outside party must be performing an institutional service or function for which the school would otherwise use employees. The service providers must be acting for the school, not just selling products and services. The school must not disclose education records to an outside service provider unless it, the school, can control that party's maintenance, use, and redisclosure of education records. This could mean, for example, requiring a contractor to maintain education records in a particular manner and to make them available to parents and eligible students upon request. The school must ensure that the outside service provider does not use or disclose education records except in strict accordance with the requirements established by the school that discloses the records. The education records may be used only for the purposes for which it was disclosed, and the provider may not use PII for education records for their own purposes. One way to make sure this happens is to include these requirements in a written agreement or contract. The outside service provider must meet the criteria for what it means to be a school official with legitimate educational interests, that is in the school's annual notification of rights. Another exception to FERPA's general consent rule is a disclosure that is in connection with a health or safety emergency. Disclosures under this exception must be made only to deal with emergencies. It does not allow for disclosures on a routine, non-emergency basis, such as the routine sharing of non-directory student information with the local police department or with public health authorities. Once you have determined that a health or safety emergency exists, you may disclose whatever information is necessary to protect the health or safety of a student or other individuals. The disclosure must be made to appropriate authorities who can deal with the emergency. Again, the disclosure must be related to an actual, impending, or imminent emergency. We also made some clarification in the FERPA regulations in 2008 to the health or safety emergency exception. Specifically, we clarified that school officials have the flexibility in determining whether a disclosure can be made under the emergency exception, and if there's a rational basis for the school's determination that an emergency exists and that the disclosure was made to appropriate parties, then the department will not substitute its judgment for that of the schools. Articulable and significant threat means that a school official can explain why, based on all the information then available, he or she reasonably believes that an emergency exists. For example, if a student poses a significant threat, such as a threat of substantial bodily harm to any person, including himself, the school official may disclose education records to any person whose knowledge of information from those records will assist in protecting a person from that threat. With regard to an eligible student, we include parents as an appropriate party because often they are in the best position to help the student. Directory information is defined as PII that is not generally considered harmful or an invasion of privacy if disclosed. These are the items that you might find in a school yearbook, a sports program, or a student directory. Directory information cannot include a student's social security number and generally cannot include a student's ID number except under certain circumstances. You may disclose a student's ID number or other unique identifier on a student's ID badge, but only if the identifier cannot be used to gain access to education records when it is used by itself. Parents and eligible students cannot opt out of directory information in order to prevent the school from requiring a student to wear or display a student ID or badge. Now here's something you may want to consider for safety reasons. A school may adopt a limited directory information policy. The school can decide that they will only disclose directory information to certain parties or for certain purposes or both. The school must specify its limited directory information policy in the public notice to parents and students. For example, a school can make a policy that they will not disclose directory information to marketers, but will provide the directory information only for other explicit purposes, such as the yearbook information or information to parents. However, if you do this, the school has to adhere to its stated policy in the directory information notice, or revise the policy and reissue the notice, providing parents and eligible students an opportunity to opt out. Another important and relevant exception to the general consent rule is a provision that permits schools to disclose PII from education records in order to comply with a judicial order or lawfully issued subpoena. While you don't have to get consent to comply with the order or subpoena, you do have to make a reasonable effort to notify the parent or eligible student. Of course, there are exceptions to the notification requirement. If you get a subpoena for a law enforcement purpose and the court or issuing agency has ordered that you not tell the parent or student about the subpoena, then you're not required by FERPA to notify them. If the U.S. Attorney General issues an ex parte order for information in a terrorism investigation, FERPA doesn't require that you notify them. Also, if the school and the parent or the school and the eligible student are in litigation with each other, you may disclose PII from the student's education records to the court without a subpoena or court order. Under FERPA, education records do not include law enforcement unit records. A law enforcement unit is defined as any individual, office, or other part of a school that is officially recognized or designated by the school to maintain the security and safety of the school and enforce laws. Now, schools vary in who they authorize or designate to be their law enforcement unit, usually depending on their size and resources. Some larger school districts and post-secondary institutions have their own fully equipped campus police units, while others have smaller security offices. Other schools designate a vice principal or other school official to act as the law enforcement unit official. And others utilize local police officers, off-duty officers, and SROs as their law enforcement unit. A law enforcement unit record is defined in FERPA as a record that is created by and for a law enforcement purpose and is maintained by a law enforcement unit. If the record meets this definition, it is not considered an education record and may be shared with anyone, subject to state law and/or school policy. If a copy of a law enforcement unit record is shared with a principal or dean, for example, the copy of that record maintained by the principal or dean is an education record because it meets the definition of education record and is no longer maintained by the law enforcement unit. However, the original law enforcement unit record, still maintained as the school's law enforcement unit, does not lose its status as a law enforcement unit record merely because a copy of it was shared with another component of the school. One of the things that appears to be a source of confusion is the matter of whether a law enforcement unit official can be a school official under FERPA. As a school official, a law enforcement unit official would be able to have access to PII from students' education records. They may be considered school officials as long as they meet the criteria, which we talked about before, for who constitutes a school official and what constitutes legitimate educational interests that are set forth in the school's annual notification of FERPA rights. Considering a law enforcement unit official to be a school official is easy when you are talking about employees of the school. But when you're dealing with SROs or other local law enforcement unit officials, local law enforcement officials, they can also be considered school officials, but you need to be cautious. In order to consider an outside party acting as a law enforcement unit official as a school official, you must follow the outsourcing requirements we went over in slides 13 through 15. Once you determine that they meet the outsourcing requirements, you may consider them a school official and provide them with PII from education records if necessary to do their jobs. They may only use that information for the purposes for which it was disclosed. Like all employees of the school, an SRO or other outside law enforcement official serving as your law enforcement unit official and as a school official may not redisclose the PII from students' education records that they receive from the school. This is very important. We found the school in violation of FERPA for utilizing an SRO, but he did not meet the outsourcing requirements to be considered a school official. So he should not have been given access to education records, which he was. He also shared information he got from the school with his local sheriff's department where he worked. That, of course, was a violation of FERPA because the parent had not provided consent and it did not meet any of the exceptions under FERPA. We discussed directory information previously. Just know that you may disclose properly designated directory information to local police. If your school has a limited directory information policy, you would need to be sure that your policy allows for disclosure to the local law enforcement. And also, as we discussed, the law enforcement unit may share law enforcement unit records with anyone pursuant to state law or local policy. You may be considering putting together a threat assessment team if you don't already have one. Threat assessment teams are more common at the university level, but it's my understanding that more and more schools at the elementary, secondary level are establishing these teams. Oftentimes, schools need assistance in determining whether a health or safety emergency exists and whether and to whom information from a student's education records should be disclosed under FERPA's health or safety emergency exception. A threat assessment team is a good way to utilize the expertise of professionals in making these determinations. If your school has a threat assessment team, you may have members of that team that are not school employees. In order for these members to have access to PII from student education records, once again, they must qualify as school officials with legitimate educational interests. And as we talked about before, this means you will need to follow the outsourcing requirements in FERPA, which is part of the school official exception in the FERPA regulations. Now, while it's not a requirement of FERPA, a school may wish to have a written agreement with members of the team specifying compliance with FERPA. Just to clarify, a school official may share information that is based on personal knowledge or about something that he or she observed. For example, you witness a student threatening another student. Your knowledge of this event is not from an education record, but from your own observation. Therefore, you may share that information with parents, with the principal, etc. In the education community, there is a lot of confusion about the application of the HIPAA privacy rule. The privacy rule of HIPAA does not apply to records that are protected by FERPA. Let me say that again. The privacy rule of HIPAA does not apply to records that are protected by FERPA. The HIPAA privacy rule specifically includes an exemption for those records that are protected by FERPA. The reason for this exemption is that Congress, through FERPA, previously addressed how education records should be protected. Other HIPAA rules might apply, such as a rule that has to do with how to transmit health records. But schools must follow FERPA and not the HIPAA privacy rule when it comes to whether a school may disclose PII from a student's education record for Medicaid or insurance reimbursement or for any other reason. A few years ago, my office worked with HHS on developing joint guidance on FERPA and HIPAA. If you would like to have a copy of that guidance, it's on FPCO's website. Here's a shortcut, www.ed.gov/FPCO. I'll give that to you again. Or you can email me at ferpa@ed.gov and ask for the link. Some post-secondary institutions have health clinics that treat students, employees, and sometimes family members of students and employees. Both education records and treatment records are exempt from the HIPAA privacy rule because they are both protected by FERPA. Treatment records are records on an eligible student that are made or maintained by a medical professional and used only in connection with treatment of the student. A treatment record is an exemption to the definition of education record and provides the school with more protection of those records. And this is explained in detail in the joint FERPA-HIPAA guidance that I mentioned. You see here on this slide, while health records of eligible students are subject to FERPA, either as an education record or as a treatment record, a college or university's clinic may be subject to HIPAA as a covered entity and provide health care to non-students. In that case, the school will have to comply with both FERPA for health records of students and with HIPAA for health records of non-students. Here's a name and the link to the joint guidance that I mentioned. While it may seem that I covered a lot of information today, I can assure you there is a lot more to be said. So if you have questions about FERPA, please do not hesitate to contact FPCO. Understanding the law will help you respond appropriately and effectively when challenges arise. Here are some of the guidance documents that you will find on our website. One very interesting one that we did for mostly post-secondary institutions is addressing emergencies on campus, and we did that in conjunction with the Office of Post-Secondary Education. We have the FERPA HIPAA guidance. We have a guidance related to emergencies and disasters. We have a brochure that was published after the Virginia Tech incident in 2007, Balancing Student Privacy and School Safety. You can also get a copy of our current FERPA regulations. You could get a copy of the most recent amendments to the regulation. And then you can also obtain the model notifications that I've spoke about, one for LEAs and one for post-secondary. And school officials may sign up for our listserv so that you can be alerted when new guidance documents or regulations come out. Here is our contact information. We have an email box dedicated to answering FERPA questions from school officials. FPCO is committed to working with school officials and helping them understand their responsibilities under FERPA. Not only do we investigate complaints filed by parents and eligible students, but we also provide technical assistance on FERPA. So please do not hesitate to contact us if you need assistance. Thank you very much.
We will now take a few questions from our participants. Remember to pose your question using the Q&A chat function on your computer screen.
Yes, I have a question, and it reads as, regarding parents and students who opt out of the directory information, is it safe to say that you're saying that the general information such as parent name, student address, and parent contact information cannot be given to law enforcement if they request such information from the school as far as in completing the process of an investigation for an event that happened off school grounds?
Well, the way to understand directory information is to understand that it is just another exception to the prior consent general rule in FERPA. So usually directory information is used for yearbooks, directories, disclosure to the media, or to anyone that asks. But if there is a law enforcement investigation going on, they would either have to get directory information on a parent or student that is not opted out, or they would have to provide you with a subpoena. Typically, law enforcement, when they are investigating and need access to education records, should utilize a subpoena so that the school can comply with that. And of course, as we talked about, you would need to notify the parent or eligible student, provide them with an opportunity to opt out. In some cases, it's going to be a law enforcement investigation and they will not want you to notify them. And if they tell you not to notify them, you should get that in writing, and you don't have to do that.
Thank you. Let me see if we have any more questions. Give it a couple more minutes. Somebody might be typing. Okay, so it looks like we have no further questions. I'll switch this back to our TA Center. Sean?
Thank you. Okay, thanks everyone for participating today on our webinar and Q&A session. That's all we have to do today. We hope that you found the information provided today useful and that you will leave with a better understanding of information sharing and the Family Educational Rights and Privacy Act, or FERPA, and the Health Insurance Portability and Accountability Act, or HIPAA, for schools and post-secondary institutions, If you would like to listen to this webinar again or share it with others, the archived webinar and other supporting documents will be available on the REMS TA Center website at http://rems.ed.gov under the webinars section of the site in approximately 5 business days. In addition, we invite you to visit the REMS TA Center website anytime for additional resources, publications, and trainings to help you in your emergency management for schools planning efforts. Thank you again for joining us today. This concludes our webinar.